Good morning.
Good morning, folks. We will get started in a few minutes. We still have people joining us, so we'll wait a few more minutes. Got about 130 people on right now, and we'll wait a few minutes until people all join us. Monique, what was total reservations?
There were 289.
I'm sorry?
289.
289. Okay.
89.
We'll wait a few more minutes. I see people still joining pretty rapidly. See a lot of familiar faces online here. It's great to see everybody. Monique, I'll start when you tell me I should.
Yeah, we had a few people who just emailed. They didn't get the code. So it's a little after 10. I'd say let's go ahead and start.
Okay. All right. Good morning, everybody. My name is Matt Mayhood. I'm president and CEO of the Silicon Valley organization. I think I've probably met many of you, but if I haven't, welcome to the SVO virtual Zoom call here this morning on our part of our COVID-19 business resources series. Obviously, these are incredibly difficult, unprecedented times, and with the shelter in place and the mandates that are coming down from our government and new information coming down every day, it's our goal at the SVO to try to provide you with the information, the tools, the resources, and even the connections to keep your business surviving and thriving during this very challenging time. This morning, we're going to be hearing from SVO member Hopkins and Carley on the implications of COVID-19 and what that may be having on the workforce. Hopkins and Carley, they've been a member of the SVO and this Chamber of Commerce since 1968, and we're very thankful for their partnership and their support. I want to take care of little housekeeping items. Some of us are getting really good at being on Zoom calls. It's a new technology for many people, but as you all dialed in, you were muted upon entry. We apologize for that, but it's the best way to manage the dialogue and the conversation. We will open up the last 15 minutes of this session for Q&A. So if you have a question that is not addressed during the presentation, there's two ways you can address that. One, you can type it into the chat box and do that, and we can see that as we go. And the attorneys will be monitoring that and trying to answer your questions as we go. So without further ado, we have about 184 people on the call. So it's my pleasure to introduce Karen Cogbell and Sean Bottomley. They're both attorneys with Hopkins and Carley in their employment group. Karen and Sean, thank you very much for being here with us this morning to break down the new employment laws that we're all seeing. I know our members and the community is very eager to have their questions answered today and hear your presentation. So thank you very much, and make sure your volume's turned up on your computer. It's the F3 button, so make sure everybody can hear, and you'll be muted throughout the call. And I'll turn it over to Karen and Sean. Go.
Excellent. Thank you, Matt. So I am Karen Cogbell. I am a shareholder at Hopkins and Carley. Before I turn it over to my colleague, Sean, I just want to give a few kind of brief remarks as well. So before we begin, there's a little caveat I want to share with all of you, which is that the information we are sharing with you today is current as of today. As Matt indicated, there are a lot of things changing. We are dealing with statutes that were enacted just these past few weeks. And as the federal government and the various agencies try to determine what these mean and how they in fact impact employers and employees, things are changing. The Department of Labor has done, for example, 3 updates to their frequently asked questions. Their most recent update was on Saturday. We have included those in today's presentation, but I do expect things will change and there'll be more clarification to some of the questions that are being asked. The overview of what we're going to do today is we're going to talk first about the emergency paid sick leave. Then we're going to talk about expanded FMLA or FMLA plus. We'll talk about the small business exemption, what it means to be a healthcare provider and that exemption, the interplay between the various leaves and company policies that you might already have in place. Throughout this, we will sprinkle in some questions that we received prior to the presentation. And as Matt indicated, if you have additional questions, please insert them into the chat box and we'll address those as we go or at the very end. Once we're done talking about the leaves, we will briefly touch on what to do if you have an employee who tests positive for COVID-19. And then finally, the unfortunate topic, if you have to do a reduction in force or make modifications to your workforce or hours worked, just some tips and things to keep in mind as you do that. So I will now turn it over to Sean, who will start us with the emergency paid sick leave.
And we're sharing one screen for video, so we'll be pushing it back and forth between the two of us. So I'm going to go over a few of the basics of the emergency paid sick leave. The first point that I'll bring up is it's going to affect April 1st, 2020, not 2010. So ignore that 2010, that should be 2020. So tomorrow, a lot of email blasts and notifications from firms and HR websites was saying April 2nd because that was the outside date, but it's now been set for April 1st. It's also going to apply to any employer with less than 500 employees at any time between that window of April 1st and December 31st, 2020. It's also going to apply to some public employers too. We've had a few questions about whether or not any particular employers are exempt from the statute, from the acts, specifically for emergency paid sick leave. There are no employers that are outright exempt at the start. There are some exemptions that are going to apply, though, if certain qualifications are met. So there's going to be a small business exception, which Karen's going to talk about later into the slides. There are also some employers who can exempt specific employees. So although they themselves, the employers, are covered and fall into the act and must actually provide this leave, they can actually exempt particular employees, and those are limited to healthcare providers and emergency responders. Those have broad definitions with how the Department of Labor has described those positions. And so if you're curious about what those include, it's pretty wide ranging. It's going to include anything from people that work at doctors' offices, pharmacies, laboratories, and medical testing facilities. It's a generally broad description, and the employer has the ability to exempt those employees out on their own. However, if there are employees that do not fall into that category, the employer is actually still required to comply with this act. The next big thing about the act is that it provides for 2 weeks paid sick leave And that's going to be on a employee by employee basis about how those 2 weeks are calculated. And for full-time employees, we know that that hour is capped at 80. And consider full-time employees being anybody that works over 40 hours in a week and includes salaried people. It gets a little bit more tricky when we're dealing with part-time employees because the cap is no longer, the cap is always going to be there, but the actual amount of hours that employee might take will differentiate based on their normal schedule. And we're also going to have 6 qualifying reasons, which is going to be the next slide that we're going to get to. The paid sick leave is going to be in addition to other leaves that the company might already apply and provide to their employees under their company policies or under California law, for example, or any other federal or state laws that are going to apply. One of the other questions that we've gotten is, how do you separate out when an employee is going to be using their their emergencies paid sick leave under this act, as opposed to sick leave or PTO under company policies under the California Paid Sick Leave Act? And the general rule is that the employee can opt to use the emergency paid sick leave if they meet one of the requirements, one of those 6 that we're going to get to in a moment. And that takes priority over all of the other leaves. So if the employee might also qualify for using, let's say, California paid sick leave, that is a separate pool that the employee will still have access to after the fact, after they run through their available sick leave under this emergency paid sick leave. And the other key thing to remember is that there's no eligibility requirement beyond just being an employee at the time. Unlike the expanded FMLA Act, which we're going to get into with Karen, if you're an employee from April 1st, 2020 through December 31st, 2020, and the employer is covered by the act, you get it instantly, regardless of whether or not you've been working for a certain amount of days or anything. A few important points as far as employees: this is all under federal law, which means that what we consider to be an employee in California might not be an employee under federal law. One of the easiest examples that I can bring up is independent contractors. California has this new AB5 law, which has the ABC test, which changed a lot of the environment about who is an employee and who's an independent contractor. So you could be an employee under California law and not an employee under this act. So it's important to see that distinction when you're counting up how many employees you have to see whether or not you're beneath or above that 500 mark. So as I mentioned earlier, there's going to be 6 qualifying reasons for using paid sick leave. I'm sure many of you have already looked at these. I'm going to bring attention to specifically one of them, which is the 5th reason. And if you look at the language about how reasons 1 through 4 and 6 are all phrased, you'll see that they're all directly, as a consequence, directly impacted or the result of a COVID-19 related instance. 5 is really the only one that's somewhat independent of COVID-19, and by that I mean COVID-19 isn't the actual cause of the inability to work for the employee. It's a indirect consequence. So as a consequence of COVID-19, it shuts down a school or a place of care, and it requires the employee to take care of their son or daughter in those instances. That's going to be important when we get into the question of whether or not intermittent leave is going to be available. But generally speaking, the rest of these are all related to directly related to a COVID-19 causing effect. And I think of what we're seeing right now in the DOL guidance and the FAQs that they're providing is, and the general consensus is going to be that the shelter-in-place orders that we're seeing in a lot of California counties, all the way from well, up here, Santa Clara, San Francisco, the Bay Area, all the way down the coast, everywhere else in California, where we're seeing these shelter-in-place orders that require businesses to either close down or stop operating in certain locations. The fact that the business is closing down and employment might dry up for certain employees because of those shelter-in-place orders is not going to trigger that first number one cause there. And we're going to answer some questions that get into that in a little bit more detail later on. Go to the next slide. A few other basics about this law. There are caps on the amount that the employer is required to pay the employee. And that's going to be important for a few reasons. One of them is you've got the tax benefit that's coming up, the tax credit that employers are going to be able to utilize when they're providing leave under this. And so knowing where the limits of that tax credit is going to extend to is important. It also informs the employer of what records to keep as far as that tax credit and to figure out how much the employee is going to be getting paid. Obviously, it's directly related to how much the employer has to pay the employee in any given pay period. And it's also going to come into the concept of supplementing income if that's something that the employer and the employee want to engage in mutually. For the first 3 reasons of the 6 reasons that support paid sick leave, there is a higher limit on a daily and an aggregate basis as far as what the employer has to be putting forth to pay the employee. And you also see there it's $511 a day or $51.10 in the aggregate over that 2-week period. For the reasons 4 through 6, it's a lower amount. It's 2/3 of the regular rate of pay, and that's going to be capped at $200 a day or $2,000 in the aggregate. We also have a section in here about the extended FMLA, again, which Karen's going to talk about that briefly, but that pay is also limited to 2/3 and that $200 per day and the $12,000 in the aggregate. So when we're talking about that calculation of pay and how much the employee is going to be capped at in the aggregate, in the daily, we need to figure out how do we determine how many hours the employee is going to be paid and how that hourly rate gets multiplied by the regular rate of pay, which is what the Act calls for. So a lot of interplay between historical data for the company, and this is where we really get into it. So this slide is focused on part-time employees, but generally speaking, the hour amount is capped at 80. And in order to figure out how many hours the employee gets to utilize per week, which is different from the cap. The cap is over the entire 2-week period. We can only go up to 80. The average amount of hours that the employee works also needs to come into this. And the best example I can give is if you have an employee that's working 50 hours a week on average, and let's say that they're hourly, then the employee can use 50 hours of paid sick leave under this act in their first week and 30 hours of paid sick leave in the next week to get to that 80 cap. So for full-time and part-time employees, it's important to figure out what that average hourly work is over their normal employment. There's no clear guidance as how to treat salaried employees. So at the moment, the salaried employees should really be treated as working 40 hours a week on average. It's when you get to the hourly workers who are consistently working overtime that we need to actually look back. And the way we look back is we look back 6 months and we look to see what their average amount of hours worked over the last 6-month period was. And if there isn't 6 months of data, then we go to whatever we do have within the last 6 months. And if there's no data in the last 6 months, either because the employee wasn't working because they were on some sort of leave, or they were not working at all because they were just hired when this act went into effect, Then we look at the intended amount at the time of hire. If there is no intended amount at the time of hire, then we look at the entire term of the employment, even if that requires us to go beyond 6 months. And if we don't have that because the employee is brand new or there's no intended amount of time for the schedule at the time of hire, the DOL hasn't provided guidance on this, but the best and probably safest bet is to look at other employees that are similarly situated, other positions that they're in that match this particular employee, and figuring out, okay, well, these employees work often 30 hours a week. We've looked at their numbers, so let's apply that number to this new employee who has no data for us to use. Beyond that, the next critical point is going to be, what's the rate that we pay these employees at? And this is another important distinction between what we're often used to in California when we're dealing with the regular rate of pay, which we all know applies to overtime, and the language that this act uses, which is the federal law and the federal regular rate of pay. The difference can be important. Under California law, there are some things, some types of pay that instead of looking at the complete total number of hours worked by the employee within a pay period, you only work at their regular or their straight time wages. So to back it up a bit, under the federal regular rate of pay, it's a weighted average of the employee's hourly rate. So you look at all of the pay that qualifies as compensation under federal rules and regulations, and you divide that by the total amount of hours that employee worked in the week, regardless of whether or not those are overtime or regular time hours under either state or federal. You take that compensation, you divide it by the number of hours worked, and you've got your regular rate of pay. California can be different. There was a case that came out in 2018 that said for things like flat sum bonuses, we only look at the regular amount of hours that the employee worked, which generally bumps up the regular rate of pay. So we need to make sure that we're using the right rate of pay, or at least the right rate of pay under federal law when we're using these hours and paying employees under both this Emergency Paid Sick Leave Act, as well as the extended FMLA. They both use the same standard. The other interesting thing that we also have to consider is that when we're talking about the regular rate of pay for overtime, we usually are talking about the same pay period that we're standing in at the moment. We look at the hours of the last week or 2 weeks or semi-month period, and we figure out, okay, for that period, that's the regular rate of pay for all the overtime hours worked. But because the Paid Sick Leave Act is prospective and we're looking into the future to guess how many hours the employee might be working or might have worked, and we need to compensate them for that, the DOL, Department of Labor, has suggested using a 6-month look back of all of the regular rates of pay that applied over the last 6 months and taking that average and applying it to the hours, again, that we also determined were normal from looking at 6 months back, to figure out what amount we're going to be paying to employees when they use paid sick leave. And again, the same rules apply. We look back 6 months to get the average. If we don't have 6 months, we use what we have. And if we don't have anything, then we need to look at what was intended as the regular rate of pay. And now I'm going to switch it over to Karen.
Excellent, thank you. So one of the things that Sean mentioned before we jump into the expanded FMLA is how to deal with that 80-hour cap. And the scenario that Sean gave was an employee who works more than 50 hours in a week. And exactly that scenario, they're only going to get the 80 hours at the end of those 2 weeks. If you have an employee who currently is only working a 20 to 25 hour week schedule, and that has historically been what they've been doing for the last 6 months, then under the first week that they are using this paid sick leave, they would just get that average 20 to 25 hours. And then the second week would be the same average 20 to 25 hours. So it may be that a part-time employee never reaches that cap of 80 hours in those 2 weeks because they never would have normally worked up to 80 hours in that 2 week period. The idea, just I think to keep in mind, is think about what is it that the employee realistically is missing from an hours and compensation perspective by being out for those 2 weeks. And we're not asking, the federal government has not said employers need to go above and beyond that, but we do need to sort of look to replace what that is. So the other piece of this is expanded FMLA leave, or FMLA plus. What this does is it essentially adds an additional qualifying reason for FMLA. And that is it allows employees to have the protection of the Family Medical Leave Act when they need to take time off because their child's school has closed or daycare has closed for those COVID-19 reasons. This is a 12-week period. The first 2 weeks are technically unpaid, but the employee, if they have not yet already used it and have it available, could use their 2 weeks of the emergency paid sick leave. And then the remaining 10 weeks would be, again, paid under an FMLA leave. So, and the rate of pay is the same as what we saw previously. It's the 2/3 of the regular, up to $200 a day. Here, there is a 30-day employment eligibility requirement. So this means at the time the leave starts, they have to have been working for the company for 30 days. So if you just hired an employee on March 20th, they're going to need to be there by, they're going to need to be employed as of April 19th before they would meet that eligibility requirement for the FMLA. I don't think that this is going to, I think a lot of our employees are probably going to meet that 30-day requirement. Certainly if you have somebody that's in the cusp or the gray area, let us know. But there's a slow, it's a pretty low bar on that requirement piece of it. This does not, the fact that this FMLA leave has to be paid does not mean that any other FMLA leave that an employee might take for another reason has to be paid. This is the only exception to that. Okay, so let's talk about the small business exemption. So the small business exemption applies to companies that have less than 50 employees. Here's the caveat. It is very limited. It only applies when the employee needs to take leave because of what we're going to call the child care reason. So that reason number 5. So that's because, again, their school or daycare is closed and that employee needs to stay home to be with their child. So if your employee, if he or she comes down with COVID-19, has symptoms of COVID-19, or is caring for somebody who has COVID-19, any of those other 6 reasons, even if you are a small business, you still have to provide up to 80 hours of paid sick leave to that employee. Now, for the child care exemption, in order to qualify that, and I've listed it here, but essentially an officer of the business has to determine that providing the leave would result in your company's expense and financial obligations exceeding available revenue and cause you to operate at a minimal capacity. You can also take a look at what are your capabilities and what does this specific employee do for your company, and would it be detrimental for your company to lose that employee for the potential up to 12 weeks of leave that they might take. And that goes to, is there somebody else that's qualified to take over the role? So you really want to look at what it is. This is going to be a case-by-case basis. It's not a blanket exemption. Just because you have under 50 people, you don't get to necessarily take advantage of this. And just because you might be able to take advantage of it for one employee doesn't mean you can for another employee. Okay, the healthcare provider exemption. The Department of Labor clarified over the weekend. They gave us a definition of what it means to be a healthcare provider. It's lengthy. I'll allow you guys to read it. We'll also circulate it in writing to you guys afterwards, but it's pretty broad. So, if you have an employee, right, who is going to be working at a doctor's office, hospital, healthcare center, nursing facility, retirement community, even laboratory or medical testing, right, that employee is not necessarily entitled to these leaves. Now, with that said, the Department of Labor, as you'll see in the last bullet point, strongly encourages employers to be judicious when you're providing this definition. They certainly, there's sort of twofold, right? We want businesses to be able to continue to operate, especially these essential businesses that we need in the healthcare realm. But at the same time, if you've got an employee who themselves has tested positive for COVID-19, you also do not want them in your workforce and potentially risking infection and the spread of the virus to other employees. So although you can exercise the exemption, please be mindful and cautious in how you do it. Okay, so we received a few questions ahead of time, and they're all somewhat related, but let me give you the scenario. So if your business is currently not operating because either you're not an essential business, so you've had to shut down because of the shelter in place or the stay-home order that the governor issued, or there's just a lack of work. Maybe you could operate, but you just don't have the clients and customers to do so. The question is, does this trigger the paid sick leave or the FMLA plus? And the answer is no. The good rule of thumb is that the employee has to otherwise be able and eligible to work, right? Work is available for them, but because of either their own illness or taking care of somebody else, or because the school has been shut down and they need to be the child care provider, they cannot work. So that relates to if the employee is currently on furlough, maybe you had to let folks know last week that you've got to reduce their schedules and they're going to be off for a few weeks. That does not all of a sudden tomorrow mean they can cash in and take paid sick leave. So those employees should be applying for unemployment benefits from the state. Now, we had a question about folks who the employee cannot telework, maybe the nature of the work, maybe they're instructors, they're teachers, that it requires some type of, it cannot be done telecommuting. Can he or she take the leave? The answer is no. That would be a scenario where the work is not available for them, not because he or she is sick, but because of the nature of the business. And then the final one is, and I've had a lot of clients ask this question, is that the employee wants to stay home. Essentially, they've decided they want to self-quarantine. The employee themselves is not sick. They're not experiencing symptoms of COVID-19. They're not taking care of a child, but they just feel that it would be better for them to stay home in this moment. And as the employee, the question is, are they entitled to paid sick leave? The answer is no. They do not qualify. They do not meet one of those 6 exemptions, 6 qualifying reasons, simply because they have chosen to self-quarantine. So in that instance, if you can provide, if you have the capability to provide them with an unpaid leave, you can do that, but you do not have an obligation under either of these statutes to pay them for that time because they don't want to report to work, and you otherwise would have work available for them. Okay, so the next question is, my employee is currently teleworking. Do either of these leaves apply? The answer is no, provided the employee is able to do their job from home right now and at the normal capacity, such that they're receiving their full wages and compensation, there is no need for them to take either of these leaves. Now that may change. If unfortunately one of that same employee ends up coming down with COVID-19 a month from now, and they're no longer able to telework, then yes, the leave at that point would now apply. Do the leave requirements apply to per diem employees? Yes. These requirements apply to all of your employees, regardless of how they are compensated. How you go about compensating for them for the paid sick leave goes back to what Sean talked about earlier, which is we've got to look back at how many hours they worked, what their compensation typically worked. That involves a lot of mathematical calculations, which we won't dive into right now, but we can certainly work with folks later on. And it does apply right to part-time employees. Okay, so I'm going to send it back over to Sean. He's going to talk about interplay with other leaves.
Thank you. Yeah, so we got some more questions here about the interplay. And the first thing to keep in mind when we're dealing with this statute is this is just one of many statutes that's going to be active when you're evaluating circumstances that apply to an employee that comes to you and says, I'm sick with this illness, this disease, it's COVID-19. And it's also going to interact with other reasons for leave that the employee might have in your company, under company policy, under state law, and what they've done historically with your company to date. So the first question here is, if an employee is currently on FMLA leave or have already taken leave, does this provide them with additional leave? No. As Karen said earlier, if really the expanded Family Medical Leave Act is adding a new basis for using FMLA leave. And so if you've already been within the scope of FMLA as a company, you've got the employee number, the employee's been working for enough time. This just gives that employee an extra basis for using that leave. They still have all uses of leave on their record. So if they've already used 10 of the 12 weeks they have under FMLA leave, then this expanded medical leave can only give them 2 extra weeks. Likewise, if they've used 11 weeks so far within the 12-month period that the company uses, they can only use 1 extra week, even though this act provides potentially for 2. So we keep track of all of the FMLA that employees have been using. The next question, my company already offers sick leave and vacation time. Do we need to provide these additional leaves under the acts? The answer is yes. You need to provide the leaves for sick paid leave or FMLA if those reasons apply to the employee. And they are in addition to anything else that you have. The employer and the employee can mutually agree to supplement the federal leave that we're talking about in this presentation with things that the company provides, but it must be mutual between both the employee and the employer. Next, can the employer dictate which leave the employee takes? No, the employee gets to choose. If they come to you and they say, I want to use paid sick leave for one of the 6 reasons, they get to use it. If they come to you and they say, I want to use expanded FMLA leave for the child care reason, they get to use it. And the last question here, does the tax credit apply to leave taken before April 1st? And what if the company provides greater leave protections to employees? And this is going to get into some of the other documentation questions we've got as well. The tax credit is going to be very specific in that it's only going to apply to leave that's provided under this act, under the rules of the act, which means that if you do anything prior to April 1st before the act comes into effect, you don't get the credit. If you do anything after the current end date, which is December 31st, 2020, you don't get the benefit. If you go above and beyond and say, well, employee, you don't fit one of the 6 reasons, but here, have this sick leave anyways, you don't get the tax benefit from this act. It must be strictly construed to the bases allowed under the act. And we'll go to the next slide. Another question we've gotten is, how does intermittent use or incremental use of these leaves apply? It's going to first depend on whether or not your employee is teleworking or not teleworking. A very strange distinction, but that's how it works, and we're going to get into the reason why. So first off, if your employee is actually required to show up to the workplace, they're not teleworking, for paid sick leave, the only option available for incremental or intermittent use of leave, which means not a full day's worth of leave, but maybe just a few hours, is for the child care leave exception. And it's only with the employer's consent. So the employer can refuse to consent for incremental leave. Instead, if the employee qualifies for the child care exception, they get the full day unless the employer allows it to be incremental and smaller. For expanded FMLA for non-teleworking employees, only with the consent of the employer is incremental or intermittent leave use allowed. So the default is always a full day if the reasons for the leave apply. And continuous, yes. And the reason why it's limited to just childcare and for non-teleworking employees is what Karen mentioned earlier. The point of the act is so we're not spreading the disease and we're really containing it. And the only one of the 6 options for paid sick leave that doesn't involve direct contact with COVID-19 is this 5th option, which is about taking care of a son or a daughter, the child care exception. For teleworking employees, it's with the mutual consent of the employer and the employee. If they want to use it on an incremental basis, they can. It's not required. The employer isn't mandated to provide it in incremental. The alternative is if it's not incremental and it applies to the employee, it's a full day that they get. But again, the department strongly encourages employers to work with employees, to collaborate with them, and to allow incremental leave where it's allowed, so that we can all kind of work together and get along and really further the purpose of the act. We'll go to the next slide now. That's good. And this is the documentation issue that I talked about briefly earlier. The first question here is, can I require an employee to submit a medical note for leave? The answer is yes, within reason. And that's because, again, when we're talking about the employer's ability to use the tax credit for supplying leave under these acts, the employer needs to be able to offer to the IRS, to whatever tax, for the tax basis, evidence that the employee qualified for the leave. And the DOL, the Department of Labor, has actually said that employers are not required to provide leave under these acts if there aren't materials sufficient to support the applicability of the tax credit. So in other words, if the employee can't produce any evidence that they are using leave under one of the qualifying reasons, the employer, at least according to the DOL, is not actually required to provide that leave. The other important thing to know is that after the first workday, the employee takes paid sick leave, the employer can ask the employee to kind of give reasonable notice that they're coming back or when they're not coming back. And so you're allowed to inquire into that. The next question, what records do I need to keep when my employee takes paid sick leave or expanded medical and family or medical leave? And the answer is whatever documents you need to establish that the employee is taking a leave under the reasons for the act. And that can be something like a doctor's note. It can be some other basis for proving that the Expanded Medical Leave Act its use is sufficient. So one of the examples that the Department of Labor gives is if a school has closed down, they can use a newspaper article that says the school has closed down as evidence to show that they have to go now take care of their child. The other thing you want to keep as far as records is careful documentation of what you've paid the employees through these leaves. And this becomes especially important when you're supplementing leaves by mutual consent between the employee and the employer, because, again, the tax benefits are limited to the leave that's applied from these acts. And if we go back a few slides and we look at the caps for the compensation, there's the $200 a day, the $511 a day limits. That's what you need to keep a record of so that when you go and try to get the tax credit, you now have good documentation to show what wages were paid through the paid sick leave and through FMLA expanded, and which ones were not. And the last question here in California is at the employer's discretion as to whether an employee can use sick leave because they are unable to work due to school closures or no daycare. No, again, this is similar to the last question we answered or an earlier question. It's not at the employer's discretion. It's going to be at the employee's discretion to use these leaves if they meet the requirements. The best practice is to provide notice to the employees as required under the acts. There's a paid sick leave requirement and paid sick leave notice requirement that's made available through the DOL. And to post that, let employees know that they have this option.
So Matt, before we jump to the Q&A, I just want to cover two super quick things real fast, which is just how to respond if your employee tests positive for COVID-19. So the biggest one is obviously you need to work with the employee to give them as much time to recover as possible. It may be that they work through their emergency paid sick leave, and that's where Sean talked about, there may be other leaves. It may invoke an ADA issue and other things like that. As far as giving notice to your other employees, You should inform fellow employees that there is a potential for exposure, but you need to do so in a way that does not disclose the coworker's identity of the quarantined employee. So try to do it in a way so that they understand they may have been exposed to it, assuming that that employee has been within the workplace within the last 14 days, but try to do it in a way that respects that employee's privacy. The final one I'm just going to say is, if you are in the unfortunate position of having to do a reduction to your workforce, please make sure that you work with legal counsel, because there are certain written notice requirements that are going to still apply depending on the size of the reduction that's necessary. Furloughs of certain lengths may trigger final pay obligations. Salaried employees should still receive their full salary regardless of the amount of work they do in a week. So if you have a salaried exempt employee, they're going to have to be off for an entire week in order for you to not pay them for that week. And then obviously just be mindful of on-call issues. You don't want to, you want to very clearly communicate to your employees when they are expected and when they're not going to be expected to be at work, so that you don't trigger an obligation to pay them for the entire time they've been waiting for something to do. The final point before we jump to our Q&A is that something to consider to Sean's piece, as far as how are you going to go back later and justify to the IRS if you want to take this tax exemption. One thing you can consider is reaching out to your payroll provider and adding an additional pay code that is like a COVID-19 pay code. So if you need to pay somebody paid sick leave under either of these acts, it could show up on their wage statement as COVID-19. It will allow you later on, when you come to the end of the year and you're trying to figure out who you paid this leave to and who you didn't, you'll be able to very easily sort that, and that might just help you out with some documentation and administrative headache later on. Okay, so I think we're ready to jump to Q&A. We've got some that are submitted. Matt, I don't know if you've got any that you want to shoot out to us, or if you want us to sort of go through the chat box.
Go through the chat box. I think you got some of them, but if you could go through the chat box really quick.
Okay, so the first question is, if you have to reduce the workforce, do you have to rehire the employees? And if so, for how long? So the answer is no. I mean, if you have to let employees go, they have no automatic right to be rehired. Now, be mindful that if the reason you are letting them go is simply because you do not have the work for them, right? And they're otherwise a good performer, let them know that they're eligible to rehire if and when business picks up. But there is no affirmative obligation to rehire that same employee, because you had to let them go at this point in time.
An earlier question posted, we can probably do that. That was asking about how to calculate the federal rate of pay. What does it include? It's going to include a lot of different pieces. It's going to include things like piece rate, salary, commissions, shift differentials, non-discretionary bonuses, promotion bonuses, cost of living adjustments, facilities that are furnished by the company. It could include lodging based on the relationship that you have with the employee and the agreement for that. So there are a lot of moving pieces you need to consider for that. I think that question was also tied with how does that apply to the cannabis industry specifically, because we're talking about federal law. And my understanding is, regardless of whether or not you're in the cannabis industry and it's lawful or unlawful to do that under federal law, the Fair Labor Standards Act, which is what this language is really based off of, still applies. So these rules still apply. Whether or not you're conducting a legal operation under federal law, you are still mandated to meet these obligations.
Okay, so what if your organization is so small that you cannot disclose, the disclosure of who's been infected or who has COVID-19 would reveal the identity? This is just one where you got to do the best you can. I mean, look, if you have an obligation to the employees to let them know if they have been potentially exposed to COVID-19, you also have an obligation to try to respect the privacy. So I think I would have to look at it on a case-by-case basis and see, is it possible that that employee who's got COVID-19 hasn't been in the workforce or hasn't been around employees such that your disclosure might be limited? And, but at the same time, I think it is, you still need to make the disclosure. The CDC is still recommending that you make the disclosure of who has, if there has been a COVID-19 outbreak. Okay, so let's, so one of the questions was very specific, this quarantine for number one. I think we've answered that. It does not apply to the shelter in place order, whether that's a county or even our state one that the governor has issued. Again, there's got to be otherwise work available for the employee, and they cannot work because they themselves are sick or need to take care of somebody else who is sick. What age applies to the child whose school is closed? There is no bright line rule on that. There is the idea, and I think intent, and I think we'll see some more guidance from the Department of Labor, but if the child is in high school, for example, and could be home on their own, then the employee arguably does not need to take this leave in order to care for that child. But there is, unfortunately, at this point, no bright line rule as to if there is an age limit, because I think it is also going to be child specific too, and to what that child's capabilities are. So
that one here, I think it was the expanded FMLA rules only apply to employers with less than 500 employees. Yes. However, when we're talking about FMLA, remember that an employee who also might be diagnosed or sick with COVID-19 might also apply and be able to use FMLA leave for that medical reason if they meet the other requirements. So you have to look at these issues through the lenses of multiple statutes. Look at it through whether or not the employee meets any of the requirements for paid sick leave. Look at it whether or not they meet the requirements for expanded FMLA leave. And then also consider whether or not they might qualify for having a disability under FEHA or ADA, whether or not they're going to have a right to use California paid sick leave, which also has protections for workers that are sick. And all of this, you have to look at it through each individual statute to make sure that you're not excluding them and saying, okay, well, we meet the standard for this one, so that your answer about leave is no, because there might be other reasons and other statutes, such as accommodation statutes, that require you to accommodate these employees.
Yeah, and so the expanded FMLA for the child care purposes, right, if the school is closed, that would not, as it stands right now, to apply if you have more than 500 employees. So that one would be the exception, and it would only apply to somebody who has less than 500 employees. So if the employee is currently off work right now,
can you read the question too?
And they're collecting unemployment, but they otherwise could work. Are they now eligible starting April 1st for these leaves? The answer is yes. So if starting tomorrow, one of these qualifying reasons becomes applicable to that employee, even if they've already been off work, they would now get that, they would now qualify. They should not be getting both unemployment and paid sick leave at the same time. And I expect that you'll get a form from the EDD asking you, if at some point you started paying paid sick leave, in which case that would be a reduction to their benefits. Related to that, if an employee has been out right now because of their own illness, so let's say they were out all of last week and they're currently out and they've already used 60 hours of paid sick leave, starting tomorrow, they get a fresh new bank of 80 hours to use if they still need it. So whether and when do furloughed employees count towards the 500 mark, and how does the analysis affect the applicability of the statute through 12/31? So the question is going to be, it's like many things, it's a little complicated, but you have to look at the number of employees you have at the date the request comes into effect, right? So let's just say right now you only have 400. Let's just say right now you have 530 employees, okay? And in a few months from now, your workforce drops and now you've got 400 employees. Well, all of those employees, if somebody needs one of these leaves, say on October 1st, and you now have 400 employees, they're going to be eligible for it. Vice versa, if you are currently under 500 and you end up onboarding a number of employees and come July 1, you are above 500, then after July 1, these statutes would not apply to you. Do you want to talk a little bit more about the 500 mark?
Yeah, and to add to that about whether or not furloughed employees count towards the 500, the Department of Labor has not said one way or the other as with specificity to furloughed employees. That's because the term furlough and a furloughed employee isn't really defined by federal law or really California law, but we have an idea of really what it is. And other federal laws, including the Federal WARN Act, treat furloughs as somewhat of a temporary layoff, where the employee is still technically employed, but they're on a leave of absence. Essentially, they're treated as being on a leave of absence. And under the WARN Act, after 6 months, that furlough essentially turns into a termination. It's a very loose way of explaining it, but at least as a far outside limit, we can probably say that if you have an employee on furlough for 6 months, even though you still qualify them as employed, there's a good chance that they might be a de facto ex-employee. And we should really figure out if the circumstances of their furlough and their employment mean that the employee count drops because they've been on furlough for so long. The other thing is, if we have circumstances relating to a furloughed employee or an employee on leave that suggests the employee is gone, such as you find out the employee is working at another job, or you find out that perhaps the furlough is never going to result in a recall, you need to evaluate those circumstances and figure out, is this actually an employee anymore, or is it a former employee, and does that affect our employee count to drop beneath the 500 limit?
So one of the things I will say to kind of give employers a little bit of reassurance, or maybe help kind of calm some of the anxiety around these new statutes, is the Department of Labor has indicated that for at least the next few weeks, they are suspending citations to employers for potential violations of these statutes, provided that the employer is, in good faith attempting to comply. And if they later discover that they should have, for example, given somebody paid sick leave and they didn't, that they retroactively go back and pay the paid sick leave. So I think, the federal government is recognizing that we are all just trying to figure out what this means as quickly as we can. And so at least, I think they've said at least until April 17th, they will not be enforcing from a penalties perspective, provided that we can show that you're trying in good faith to understand what this means and comply with it. So I have hourly employees and I need to reduce their hours. Will they be eligible for unemployment benefits? So the EBD does provide unemployment benefits when there has been a reduction in hours. The best recommendation I can give to you is you do not necessarily want to guarantee any employee that they're going to be eligible or entitled to unemployment benefits. You need to, if you're reducing their hours or you're letting them go, you need to provide them with information about how to contact the EDD and allow the EDD to sort that out. But generally speaking, yes, if there is a reduction in hours, they will be eligible for temporary unemployment. So it says, it sounds like we have to pay the COVID-19 sick leave and FMLA out of the company pocket unless the employee is off for childcare. So let me be clear, all of these are company paid benefits, even including the childcare. So if it's a COVID-19 or a childcare reason, and the employee is taking advantage of the paid sick leave or the FMLA plus, that is something that the company is paying. There are tax credits that are going to be available to sort of offset what your obligations are under the payroll. Neither Sean or I are tax experts on this. What I will tell you all is there are other issues. I know lots of you have questions about small business loans, the tax credits. I'm sure Matt and the SVO have resources to help with that. Here at Hopkins and Carley, we have what we've called the COVID-19 task force. So we are also working with employers both on this piece of it, on that piece of it, on just other issues, we are happy to address and help you.
Probably one more question there,
Yep.
Karen.
So, okay, so if you have a salaried employee who is on FMLA Plus or expanded FMLA to take care of their child, can they work with the employer for a few hours every day? Can you pay them on an hourly basis? Okay, so here's the thing with salaried employees, right? The general rule is that if a salaried employee does any work in the week, they're entitled to their full and complete salary. Now, if you have a salaried employee who needs to use this FMLA Plus bank, you could theoretically use this FMLA paid to basically reduce their salary. So they're still going to take home, let's just say they make $50,000 a year. They're still going to take home $50,000, whatever the weekly equivalent of that is. You may pay some of that as the COVID paid leave, right, for which you could take a tax credit, and you may pay some of that weekly salary as just their own weekly salary. But they need to make their complete weekly salary if they're performing any work. Now, if you are in the unfortunate position where you know they're going to be working less, or you need to reduce salary employees' compensation, you have two options. And obviously we'd want to talk about these in more detail. But one of them is to prospectively reduce a salary employee's salary on a prospective basis, provided it still meets the minimum salary requirement, which is just above $49,000. Or you could convert an otherwise salaried exempt employee to an hourly employee. Again, provided you give them sufficient notice that they're going to now be hourly, and you otherwise treat them as an hourly employee with respect to paying overtime, providing meal periods, rest breaks, recording, and doing all of those things. So there is some flexibility for you in how you work with your salaried employees in this.
And one small quick comment, when you're using any of the payment in this act to supplement under the expanded family medical leave, it's not as simple as throwing money into the bucket and offsetting the salary. You are still capped at certain amounts per day, per month. You still have to keep track of the hours. You still need the evidence to support the use of the tax benefit. That can be complicated when you get people with salaries that are exceeding the daily rate that we're talking about here with the cap and the aggregate. So be very careful when applying that.
Hey, real quick, I see a couple people asking the same question about do they need to fill out the form DE2063 form for part-time reduced hours?
So that's the EDD form that they send you. Oh no, sorry, that is the, yes, that's the notice to an employee that there's, essentially been a change, right? We typically provide that to employees at the time of a layoff or a termination. I think if there has been a reduction in hours, my suggestion would be, I don't know that it's required to do it, but I would encourage you to do that. What it does is it gives the employee something to go to the EDD with that shows the EDD that my hours have been in fact reduced, and here's something that my employer has given me to show that there's been that reduction. So it's not required as far as I'm aware of, and Sean agrees. But I think it's good practice to give employees as much as they can to help them take advantage of some of these benefits if they're going to need them.
Okay. Hey, Karen and Sean, thank you very much. It's about 11:02, and I know we said we'd go to 11 o'clock, and I'm sure people still have lots of questions. I know you took us through a lot of information in a short period of time. It's pretty complicated. The rules are changing, and I think you shed some light on some of the more difficult questions to answer. I know that we are going to repost this webinar. We're gonna record it. It's been recorded. We are going to repost it, and it'll be up on our website. Sometimes it's easier to talk to an expert other than hearing it from the webinar. Can our members reach out to either you, Karen, or Sean?
Yeah, absolutely. So we put up our email addresses are up here on the left side. Please do not hesitate to reach out to us. And like I said, we've got lots of assistance here at Hopkins and Carley to help employers through this uncertain time.
Awesome. Thank you very much. Really appreciate you guys taking time out of your busy schedule. Make sure you guys wash your hands and
Yeah.
social distance yourself after this.
Yes, we will disinfect the computers, don't worry.
Yeah, okay. So the SVO we have, and by the way, there's a question that was related to tax. I think we're putting together a tax call for April 7th with the Trinovich Pugh and Company. I believe Monique is working on that.
Yeah, next week, 10 o'clock.
Yeah, so keep an eye on the SVO website. We're updating our COVID-19 website on a daily basis with new information, tools, resources to keep you guys connected. We had about 220 people at one point on this call today, so we're trying to do our best to keep you informed and keep you connected. So continue to monitor our website for the updated information that we're producing. And on behalf of the SVO, our staff, our board of directors, we're all in this together. Let's continue to maintain our social distance and keep doing what we need to do and working to keep our businesses ready when we come out of the shelter in place. So thank you very much and go out and have a great day. Be safe, stay healthy. Thank you.
Thank you.